Gathering in Washington, D.C. yesterday and the day before this past Saturday, Sunday and Monday, and I believe Saturday night the day before, on the 22nd anniversary of Smith v. Doe, was a coalition of people against the sex offender registry who have been directly or contingently impacted by its cruel and unusual punishment. Actually, Smith v. Doe countered, and this is why it was controversial, countered the Eighth Amendment's prohibition, excuse me, against cruel and unusual punishments when the Supreme Court of the United States determined that the sex offender registry was not anything more than a mere list and did not constitute cruel and unusual punishment. Of course, that is not true. So, affiliate groups, most notably the Alliance for Constitutional Sex Offense Laws and AXAL, NARSOL, the National Association for Rational Sex Offense Laws, and WAR, Women Against the Registry, among other interested parties and groups, met in Washington, D.C., both at a conference center in Arlington, Virginia, but also before the U.S. Supreme Court, standing out front to call attention to this grave injustice. And if you don't think it's an injustice, either you've already made up your mind or you haven't had anybody who's been affected by the registry, or thirdly, as some of my most recent trolls have indicated, you don't really give a damn. So Smith v. Doe basically it was argued, um, proponents of it said, well, it's not really punishment; it's just a list. We need to have a list against these dangerous citizens. People who are against it said it is effectively a punishment and directly a punishment and always a punishment because of what it allows to have happen, which I've talked about on this channel. Namely, the list allows people in the neighborhood to find out who could be dangerous, but then it also allows them, without any fetters, without any restrictions, to go and harass you online, which you can do anonymously, even though they have laws against harassment, to call you workplace anonymously and tell them about the scary people they have working there, to go and tell the police that you're doing certain things when you're not, so they come and investigate, making for a very comfortable and potentially embarrassing situation that brings ill repute to your apartment complex, your neighborhood, your job, which gets you fired, forces you to move, or what have you, or otherwise make up stories. It also allows you, as I indicated, to be denied housing, to be denied credit. It puts you in a position where, at least in Virginia, as with other states, but particularly Virginia, it forces you to not be employable in some of the most critically at risk and in need jobs that are out there, including healthcare, including um, working with veterans, working with the poor, working with children, working in positions of authority where you're a manager, working in the medical field, working in, trying to think now, I'm drawing blanks, but funeral homes, nursing homes, um, extended care facilities for people, anywhere where you would be of greatest need, frankly, that nobody wants to work because, of course, you might do something, right? Funeral homes, you might suddenly have an urge for necrophilia. For working with children, you might certainly decide that you're interested in abusing children, and in nursing homes, the elderly, etc. And of course, this is part of the hyperbolic element of the registry that we have talked about, which is contingent. And of course, ICAC, among others, feed this registry. So it goes right up and down the vertical articulation from the judge over to probation, over to the police, over to ICAC, over to the politicians. You know, everybody's involved at some level. Well, they had their session in front of on the steps of the Supreme Court, where once again they talked about various problems that are associated with the registry. And let's not forget one of the major problems that you don't hear about as much. It just costs a lot. It costs millions and millions of dollars to set up, over a lifetime, millions to actually administer it. It requires, in many ways, police officers to be pulled off the field to fill out paperwork needlessly. It requires people of certain offenses here in Virginia starting in July. They will have to register every month, okay, or every quarter instead of annually or semi-annually. So it increases the burden of paperwork and it does absolutely nothing. Remember, most of the cases where somebody is committing a sex offense, they're committing a sex offense for the first time. Okay. So having a list of the people who did it or didn't did it or whatever the case may be, because there are many, many people on the registry who 25 years ago were under the highest tier of sexually violent predator, even though that has changed now. And they're no longer recognized as sexually violent predators. They're still on the list, and some of them for life. There are people who didn't do anything on the list for life. Okay, when I said didn't do anything, they didn't propose sex to a child. Okay? They didn't suggest anything to a child. Instead, what you have is police and prosecutors squeezing this meaning or that meaning. Well, they meant this. They said this, but what they really meant was this, even though it could be ascribed in a different fashion. Okay? And this is what these people are fighting against. Okay? And when we're talking about all these budget cuts now, when we're talking about how much things cost, money that is pushed down to the states to have this SORNA under the sex offender regulation, um, there are strings attached to that money. And certain states follow those strings, and certain states follow them to a lesser degree. And if you follow them 100%, you get all the money. If you follow them 78% or so, like Virginia, you get some of the money. But the fact of the matter is the money is wasted. It's wasted money. There's no reason why you should spend millions and millions of dollars dealing with that. Police officers should be out there dealing with the baddies, and they don't even have time to do that now. Okay. We had a theft here with one of my friends who was visiting a significant sum of money, and the police can't even prioritize that. It took 3 days for them to come and just take a statement. Okay. Why? Because as they told me, we're busy, we're doing important things. Okay. So here we have a situation now where you have something that all people who've studied this agree nobody should be on the registry for more than 5 years, and nobody should be on it for life. And we would argue further, nobody should be on it at all because it does nothing to save anybody. But certainly, if you have no actual victim, as in the case of the proactive stings, nobody was harmed. So there shouldn't be any registry for that. You shouldn't have a registry because maybe, perhaps, possibly, they might have done something. In the word of a police officer, that is, who is not trained in this area necessarily, but who is trained in how to avoid entrapment techniques, which they actually are instituting on you in these things. I mean, it's a very corrupt system, and the Supreme Court really needs to revisit this. According to these companion groups, according to many of us here in Virginia and in other states, they need to revisit this as an Eighth Amendment violation because you've been punished, you've gone to prison or jail, you've paid fines, okay, you've done a stupid psychological evaluation, which almost always finds some little thing, niggardly thing that they could focus on, right? That they could complain about some tiny little thing, and then you focus on that, and it turns out to be nothing really, and they say, well, there's really nothing here, but that's okay. We're going to make you do polygraph tests, which also aren't they aren't reliable. They're not even admissible in court. So why do they have you do them? They put you on a very, very short chain, and then eventually they have to let you go and live your life. And most people don't violate things, but they will arrest you still because they have to make it look good. They have to have a violation. That's my assessment. That's the assessment of other people. If there's no reason, no good reason to violate you, why are they violating you? On the most minute things, okay? In my case, all of them were dropped. During COVID, It was you didn't register your vehicle, which I did. It didn't get through the system yet. And you supposedly had all of these social media accounts that you were communicating with people and had a phone, all of which part of it wasn't true. I didn't have the social media accounts, and I had a phone because I was allowed by the same probation officer who arrested me to have that phone. Okay. So it's simply a ridiculous system that does nothing to keep anybody safe. That's my point. So hopefully next year you will join if they go out there um, to campaign against the sex offender registry. Understand, I am not pro sex offense. I'm not pro hurting kids or anybody. But if the Virginia General Assembly recognized that real sex abuse in a domestic partnership or domestic violence was worthy of 7 years and then you could get off the registry, and you didn't get put on till the second or third or fourth time, if that's what they were pushing this legislative session, then how does it justify putting somebody on a list for 15 years when there was no victim and there was no sex talk and there was no pictures? How does that square exactly? Except that it has to do with the public's hysteria over sex. This is Norman Michael Ation with ICAC Unpacked. Have a good day.